see me come and make some room.
Everywhere I go, I'm in the spotlight. This is a good life. I'm living bold. This is what it looks like. On the tip top of the world.
OSRA 22 is live, but what came before it? Did you know that there was an OSRA 98, an Ocean Shipping Reform Act of 1998? Hi, welcome to By Land and by Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor. That's me. I'm Lauren Beagen, founder of the Maritime Professor and of Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there is no attorney-client privilege created by this video. If you need an attorney, contact an attorney. So before we get into the discussion of the day, let's go through my top 3 stories of the week. So story number 1, today is July 1st, and that means that the ILWU and PMA contract, labor contract, expires today. There are commitments by both sides to not disrupt the flow of goods, specifically in the form of a strike. They both have said they agreed they're not going to strike. But as a general statement, look, businesses don't like uncertainty. And that's what we have here, uncertainty. Will there be a strike? They've said that there won't be. But how much can you rely on that? I mean, even if there isn't a strike, will there be slowdowns? So what happens if a dispute arises in the meantime? I mean, what happens if their relationship changes over the course of these negotiations and a strike does arise? Just because they said they don't intend to, doesn't mean that conditions might change. This certainly isn't the first time this relationship has gone and continued past the expiration of a labor contract, though. So let's not get too, overly worked up here. This isn't. We're not in uncharted territory. Go back to my episode on the history of the ILWU and the Pacific Maritime Association. There's an episode which actually, By Land and by Sea, is now on podcast, so you can go find it more easily in podcast form. But if you go back and look at that ILWU PMA labor negotiation contract episode, you'll see that this actually fairly regularly happens. But the point remains, it's still uncertainty. And business, and specifically logistics, certainly prefers certainty and the black and white and the expected actions and clear paths forward. So a few days, we're kind of in some strange world here. A few days before they were set to begin negotiations, though, the PMA released a report saying that automation saved money at the ports during COVID. And then yesterday, a day before the contract was set to expire, the ILWU released a report, or an independently contracted report was released, paid for in part by the ILWU. It was a 3 years in the making report that essentially said automation is a hindrance to port productivity. I'm going to look more into this new report and potentially look back at the other report that PMA, so essentially PMA, Pacific Maritime Association, as you would expect, said automation saved money. The ILWU, the International Longshore and Warehouse Union, basically said automation is a hindrance to port productivity. They released a report. So you have two kind of strategically timed, one right before they begin negotiations, one right before the contract expires. With conflicting reports, conflicting statements, or allegedly, and that's what's been reported. So I don't know. I still think we're fine. I still think that things are moving forward. Labor Secretary Marty Walsh, former mayor of Boston, is saying that he's not too concerned. He thinks that things are moving forward well. Let's just keep watching this. We're not in uncharted territory. The fact that the contract expires today is worth noting, but that's about it. I think that what happens now is, do they do a 30-day extension of some of their dispute resolution mechanisms? What if something happens in the next 30, 60, 90 days where there is some sort of contention between the two? That's where you would go back to the labor contract. If there isn't a labor contract in place, that's where it starts to get gray. And like I said, business and logistics and supply chain really thrives on that expectedness and anywhere that gets away from uncertainty, away from the gray area, that's where we're at. So we'll see. I'm going to continue to watch this. I think everybody's going to continue to watch this. We'll just see. Hopefully they come up with a negotiation soon. So story number 2, France has asked CMA CGM to lower their rates. G Captain, among others, reported that France is pushing for CMA CGM to give back some of their enormous profits. So CMA CGM being an ocean common carrier, give back some of their enormous profits to the French people as they struggle. The nation, as all nations really at this time, are struggling with inflation. CMA CGM is privately held by the Sade family, and they're based out of Marseille, France. So along that same vein, CMA CGM announced that they would be providing a €500 per 40-foot container, or FEU, for consumer products. So a discount, a €500 discount for consumer products imported by major retail chains to mainland France. The measure is going to be applied for 1 year, and the discount also applies to all imports to French overseas territories. A few concerns here. Maybe these two are related, maybe they're not, but they sure seem like it. So France is saying, you got to give us a discount. CMA CGM says, all right, France, we're giving you a discount. When an ocean common carrier, so there's a few concerns here. So government intervention can be a problem when it comes to ocean common carriers. I'm not saying that this is what's happening, but in general, I think it's appropriate to talk about. When an ocean carrier is owned or controlled by more than 50% of a government or governments, then the carrier is reclassified as a controlled carrier and winds up on a controlled carrier list at the FMC and maybe other regulatory agencies' watches. There are restrictions on the ability of a controlled carrier to reduce their prices without notice, among some other restrictions. I don't think we're anywhere near a 50% control here, but it's going in a strange new direction. I think government incentives and discounts maybe aren't something new, but I don't know. It's a little, it seemed like it kind of happened fast. Maybe it didn't. Maybe it just wasn't in the news. Limited incentive programs seem to be generally permissible, I'd argue, but that the intended incentive really needs to be clearly outlined for a true benefit, having a temporal element to it. So I like that they limited it for 1 year. And to be limited and narrowly tailored to the purpose. And so, I think I'd like to understand a little bit more about what's going on here to have a fully, a full and correct view of what's happening. But, a €500 discount or €500 discount, what is it narrowly tailored to? What's the purpose? So, if it's generally to help France, is that permissible? Is that supposed to be alleviating some of the problems of inflation that the French people are having? It's taking off maybe a discount for French imported goods. It's not really benefiting French trade, because wouldn't that be an export? I'd like to know more here. This doesn't seem to be that. It doesn't seem to be a controlled carrier moment. This is just a general blanket discount for French imports and only consumer imports. So what does that mean? Is that like raw materials? No, but fully finished products? Yes. There's just some questions that arise here. There also may be some European Union law considerations as well. Remember, France is part of the larger European Union, and there's some restrictions and directives on preferential treatments and unfair pricing. So Lars Jensen actually highlighted and flagged this issue on LinkedIn recently. He pointed out on his post that highlighting the unfair pricing. And so I'm not a full expert on European Union law, but I do dabble in it, and I do seem to understand different parts of it. I certainly have worked in it before. But it seems that the larger intention is so that there isn't preferential, or I guess stated in a different way, there isn't discriminatory pricing based on nationality among EU countries. That seems to be what the European Union law on unfair pricing is. Would this €500 discount fall under unfair pricing? I'm not sure. I'd have to look further into that as well under the European Union law. It's certainly going to be an interesting exercise in global trade regulations. There may also be World Trade Organization, WTO, most favored nation implications. I don't know. I'm just kind of generally discussing this. I'd like to learn more. This is pretty new. It only came out, I think, within the past 24 hours. So the details surrounding all of this are still coming out. But there's certainly some questions. Maybe it'll be totally fine. But there's some questions here that I'd just like to look a little bit deeper into. It's a pretty interesting story. So story number 3. So this third story is something that's been floating around throughout the pandemic. So this is blankings. So what's a blanking? Basically, ocean carriers can skip ports. So ocean carriers in the liner trade, that's a key word, liner trade, enjoy antitrust immunity so that they're not subject to the same monopoly laws, but it's exempted for the greater good of the overall kind of shippers of the world. This is a very simple overgeneralization. This is just trying to distinguish between liner service and tramper service. So this is for liner trade. So that's a regularly scheduled liner service. So what happens if the schedule starts to change? Let's say they could claim that the blankings are happening because of market adjustments or to account for weather or, the delays, whatever it is. But at some point, blanked sailings turn into a tramp service. And tramp service is an unscheduled service. And tramp service does not enjoy antitrust immunity. So this is something that I think that the FMC is going to have to keep watch over. I know that they certainly have been previously as part of the overall consideration of what the FMC is looking for. The Federal Maritime Commission, we've talked about them before. They are the independent regulatory agency for ocean common carriage and ocean movement for the benefit of the U.S. importer, exporter, and shipper and consumer. So this is something that the FMC is going to have to watch over. Are these blankings throughout the pandemic and certainly recently, maybe with this new shift, are they rising to the level of maybe price manipulation or, are they having a discriminatory or manipulative effect on the global regulatory or the global shipping world? Blank sailings hurt ports. They hurt dock workers. They disrupt the supply chain and the free and efficient movement of goods. So the justification for blank sailings, I think, is better be a good one. I think that blank sailings certainly necessary, certainly, corrective. But there's reports that these blank sailings are on the rise again. Project 44, as reported by GCaptain, is saying that with ocean freight spot rates in free fall and demand for containers down year on year, carriers have moved to protect profitability. These may include more profitable routes, and GCaptain is reporting that the Ocean Carrier Report that Project 44 identifies the Ocean Alliance as the most aggressive of the vessel sharing consortia or alliances, as we call them in the U.S. So consortia is the alliance version for mostly when we're talking about the European Union, in pushing for market share by keeping blank sailings below the industry average. Blankings are interesting. They really are. These are all kind of still developing stories that I've covered here today. I'm going to keep watching them. I think that there's some interesting conversations and some interesting analysis that's going to be happening in each of these different areas. We'll see. All right, well, let's get into the meat and potatoes of the day. So the Ocean Shipping Reform Act of 1998, OSRA 98. We have OSRA 22 that just passed, bringing with it the promise of solving all global regulatory problems, right? Well, not entirely, but look, I've said it before. I think it's a good start. But what happened last time? What happened before OSRA 22 when we had OSRA 98? So when OSRA 98 was being considered, there were roughly 8 years of deliberations and studies and interviews with experts and more studies and more deliberations until the final OSRA 98 language was eventually passed. So what happened? So the FMC put out a report about 2 years post OSRA 98 discussing what had changed and what benefits were now being enjoyed. OSRA 98 is the Ocean Shipping Reform Act of 98 that modified the Shipping Act of 1984. And so the Shipping Act gives the authority of the FMC to be the regulatory agency responsible for all of this. So that's how it all kind of comes together here. So there are a few different categories of change. It's not an exhaustive list. This is just a snapshot for our discussions today. So we have service contracts were amended, agreements generally were amended, tariffs were amended, unfair foreign shipping practices, and controlled carriers. Some of these I picked because they were pertinent to some of our stories today, and I think that they bring a little bit more color into our discussion. But also, just these are interesting changes that had happened. So under service contracts, so under OSRA 98, shippers and carriers were now allowed to enter into individual confidential service contracts. And there were also fewer essential terms required and no rates were made public. So this was new. These were new, these confidentially filed service contracts. And the reduction of the essential terms and that no rates were made public. This was all pretty interesting. Continuing on, and like I said, this is a snapshot. I just wanted to present overall OSRA 98 for general awareness. We'll probably dive into this a little bit deeper at some point if it warrants and if it makes sense to. But being that OSRA 98 already happened and OSRA 22 just went into effect, I thought that just having general awareness was important. So agreements were also looked at. So OSRA 98 kept limited antitrust immunity for concerted carrier activities. However, agreements could no longer prohibit service contracting by their members or require members to disclose the details of those service contract negotiations. So what does this mean? So previously there was something called conferences, ocean conferences, which essentially were like membership clubs of ocean carriers where their rates were agreed upon. So OECD, to kind of define these conferences a little bit more. OECD, Organization for Economic Cooperation and Development, it's an international outfit. So they define shipping conferences as shipping conferences refer to shipping companies that have formed an association to agree on and set freight rates and passenger fares over different shipping routes. These are different shipping conferences for different regions of the world. So shipping conferences, aside from setting rates, adopt a wide number of policies such as allocation of customers, loyalty contracts, open pricing contracts, etc. Historically, Eastern Bloc country shipping lines have not joined these conferences. So that's the definition from OECD. What's important here? Freight rates. They were agreeing on and setting freight rates. So we've talked about ocean carrier alliances before. This is different in that the alliances don't talk about rates. They can't. They're not allowed to. But they do talk about vessel sharing and other operational considerations. So OSRA 98 made that change. The world went from shipping conferences at the time to really phasing that out to now, 20 years later when ocean alliances were starting, now not 20 years from 98 is now, but 20 years later in the early 2010s when alliances were coming around, that's when alliances started. So it took 20 years for OSRA 98 to have that shift away from conferences and over to ocean alliances. And we've talked about ocean alliances before. If you'd like to know more, feel free to go check out my podcast. I can't say it enough. By Land and by Sea is now a podcast. Feel free to go check out the podcast website or wherever you get any of your podcasts. It's on most all major podcast locations now, but I covered ocean alliances and went into a general overview so that you can be more versed in what ocean alliances are, what they aren't, what they can and can't do. So tariffs were also identified in OSRA 98. So OSRA 98 eliminated the requirement that tariffs be directly filed with the Commission, with the Federal Maritime Commission, and rather they could be filed electronically, available to the public for a reasonable access charge. So a reasonable access charge. So think about this, 1998, this was a movement toward e-filing. This was a movement from instead of having to send the hard copy to the FMC, you could now file electronically. But the tariffs still needed to be available to the public for a reasonable access charge. And that was so that if you had to pay for your website, you could still charge a reasonable access charge because they didn't want this to be overly burdensome on the carriers who were filing these tariffs. Isn't that interesting? Now we know, and actually there's an open rulemaking, that reasonable access charge is likely being done away with through a new recent rulemaking because it's pretty much free or close to free, or you probably already have a website where you could put your tariff up. There's still some barriers to access to tariffs. Maybe it might be having to sign up to make a profile on the website, or maybe there are some minimal charges for tariffs. But really, tariffs are supposed to be open and available to the public. And so this is kind of a change of the times, a sign of the times from the 90s to now, where the FMC is really trying to do away with that. But so in 98, so in OSRA 98, this is what we were looking at, was they were moving from directly filing with the Commission to file electronically, also still directly with the Commission, but filed electronically and available to the public for a reasonable access charge. Foreign shipping practices were also covered. So OSRA 98 expanded the FMC's ability to guard against predatory pricing by, as the FMC report states, clarifying that pricing activities are among the practices that may constitute a condition unfavorable to shipping. So pricing is kind of one of the most important things that the FMC is monitoring, certainly one of the most important things. And so the FMC, I think I mentioned this at the outset, but I'm just going to remind you, the FMC wrote a report 2 years after OSRA 98 came out, so roughly 2000, talking about what had happened. And so that's what they were saying in this report, is that foreign shipping practices, OSRA expanded the FMC's ability to look for and guard against predatory pricing. Weren't we just talking about pricing manipulations and shipping earlier in some of the top 3 stories of the week? So see how it's important to be very intentional where rates are concerned. So specifically when you start to get into preferential rates based on nationality and or rising to the level of discriminatory practices, it's so important to have it be narrowly tailored so that there's a purpose, there's a point, there's a specific group that's supposed to be benefiting from it, and that it's a temporal in nature. And these are just kind of my general not legal advice, but general best practices when you go and try to do any sort of incentive program like that. Usually it shows itself more along the lines in terms of foreign predatory pricing and foreign shipping practices. Usually it shows itself more along the lines of restrictions of access. So let's say if France were to say that they were denying entry of all Chinese carriers, that might be something that's going to be falling under this. Although there's a question of standing potentially in that. Can the U.S. protect the general supply chain even when they don't have a direct stake in the game? In that example, would be France and China. To be considered, to be determined by fact-based analysis in specific instance. Or another example, saying that no U.S. cargo could enter France. What if that were the consideration here? Now, that would be arguably very discriminatory. That's not the situation here, but that's where this starts to come into play. Or maybe all U.S. cargo had a surcharge attached. That's the predatory pricing piece. That could be discriminatory. Saying that all U.S. cargo that was coming into France had a surcharge attached. So instead of making it preferential for, the 500 euro discount coming in on French imports for consumer goods, maybe they would flip it and make it discriminatory so that it's something maybe against the U.S. so that all other imports would not have this surcharge, but U.S. cargo would have a surcharge. That could be discriminatory. I mean, these are very fact-intensive analyses, but these are just some examples to kind of bring light and color to what we're talking about here. So as the FMC report states, OSRA 98 also made the suspension of service contracts available as a remedy to address unfair foreign practices. So suspension of service contracts could be something that the FMC could do. So if you want to know more about these areas, Foreign Shipping Practices Act of 1998 is found at 46 U.S.C., the U.S. Code, sections 42301-42307, and section 19 of the Merchant Marine Act of 1920, which is 46 U.S.C. 42101 and 42109. I suggest you have a look. There's some pretty interesting areas here, and there's some pretty significant remedies that the FMC can impose. And certainly, as we're discussing, OSRA 98 gave some of those authorities and those expansions. But these are just generally some pretty interesting areas of global regulatory and global shipping law. OTI licensing and bonding, that was also covered. So OSRA 98 made it so that NVOCCs and freight forwarders were required to obtain a license, and that every OTI, Ocean Transportation Intermediary, have a bond or other financial security on file with the Commission. That's pretty interesting. That's pretty significant. Controlled carriers is another area that OSRA 98 covered. So under OSRA 98, the FMC was now able to expand the reach of the controlled carrier jurisdiction. So we talked about controlled carriers a little bit, but previously controlled carriers were only when it operates vessels registered under the government that it controls. So, you could potentially have some flagging out. Now, as we know it, it's government control or ownership, not necessarily tied to vessels registered under that government. So like I said, this helped eliminate the flagging out, the changing of the flag so that the controlled carrier status wasn't triggered. They wanted to get around some of these games that might have happened. So OSRA 98 also enumerated and clarified the foreign activities that create unfavorable conditions to shipping in the U.S. foreign trades. So stating pricing practices being among those activities that may create unfavorable conditions. That kind of keeps coming up here, huh? So usually this is in relation to a 30-day notice requirement for tariff publications. So this ensures that no unfair and unexpected tariff price changes by a government-owned, backed, or ocean carrier was happening. And that's what we see today. If you're on the controlled carrier list, you have a requirement of a 30-day notice for tariff publications. That's going up or down, because if you're a government-backed entity and you're able to price drop and take over the market, then that's not fair. So that's where it starts to ensure some of that no unfair and unexpected tariff price changes by a government that's either owned or backed ocean common carrier. So the FMC's report also had some interesting recap finding in bullet points at the end. I think that these, like I said, this is just an overview. I wanted to quickly hit 98. I didn't want to go too far into detail because some of these, certainly none of the things we're really talking about here, but some of these things, I think it's important to focus on OSRA 98, but excuse me, OSRA 22. But certainly OSRA 98, it's important to know the history. It's important to know where we started, where we came from. And that's what we're doing here. So one of the areas at the end of the FMC's report in one of the bullet points was, it is now the internet, not the FMC's ATFI system, that is the portal for tariff information. I mean, to be in 1998 again, where the internet was this huge new thing. I guess it still is. It was this huge new amorphous thing. I think we're just more comfortable with it, but imagine that now this is what it said. It's now the internet, not the system, that's the portal for tariff information. Arguably, it's one and the same these days, probably, but it was an interesting point. So another bullet point stated, tariffs are no longer the center stage for ocean carrier rate information, but more the coordinating link across most service contracts. That's interesting. That's interesting that they acknowledged through this report that tariffs were no longer the primary focus, and really it was the service contracts. It's true. Service contracts really do rule the day, and tariffs are provided as general information sources for the most part. So tariffs also provide some key essential terms and rules that may not otherwise be captured by service contracts. But, for the most part, service contracts seem to be the majority. And this other last piece that I'm going to bring up, instantaneous electronic information exchange has ushered in the era of globalization, breaking down traditional national and market boundaries. This was the bullet point at the end of the report. Instantaneous electronic information exchange has ushered in the era of globalization. I mean, that's true. Breaking down traditional national market boundaries, where we were all able to get on the internet in the 90s. Go back to this in your mind. The 90s. This was 1998. It's so interesting to think back to 1998 and the advent of what was to come with e-commerce and just a societal shift, everything getting online. So that's it. That's a snapshot. We've had some pretty lengthy discussions recently, so I wanted to keep this one quick. I thought that, like I said, it was important that we covered the last OSRA and see what it looked like as we entered into the new OSRA 22 world. We may cover more areas of OSRA 98. There's a lot more that happened, but these were just some general overviews. These were just some suggestions of things that might be important, things that you should maybe look back at, see what OSRA 98 had to offer, see how it changed the industry, how the industry changed in 98, going from conferences over to alliances. These were just some overviews. I think we're going to probably dive in deeper at another time. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. But if you have specific legal questions, feel free to reach out to me at my legal company, Squall Strategies. Otherwise, for the non-legal questions, the e-learning, the general industry information and insights, and this podcast by land and by sea, come find me at the Maritime Professor. If you like these videos, let me know. Comment, like, and share. If you missed any previous videos, these videos now live on podcasts. They also still live on my YouTube page, by Land and by Sea, presented by the Maritime Professor, but they are podcastable now. Go ahead, download them, listen to them at your leisure when you're getting ready and brushing your teeth in the morning, when you're commuting in and out of work, or, when you're cooking dinner. That's when I find myself listening to podcasts. And while you're at it, check out our website, themaritimeprofessor.com. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.